Recognize the gentlelady from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman. It seems ironic that today's hearing is titled Judicial Overreach and Constitutional Limits on the Federal Courts, because if we really care about constitutional limits, we should start by confronting the recent attacks on judicial independence, attacks that themselves defy the Constitution. In the past few months, we've seen Elon Musk, President Trump, and even members of Congress call for the impeachment of judges, not for misconduct, but because they don't like their rulings, and that's not how a constitutional democracy works. You know, it's true that members of the judiciary were not elected by the Electoral College. That is beside the point. As my colleague, Mr. Massey, pointed out, when Congress enacts a law, signed into law by the president can overturn that law with a statement, which is essentially what an executive order is. And that judges are making that finding is the role that they have been assigned. Now, Professor Shaw, the recent federal court decisions, which, by the way, have been made by judges appointed by both political parties, have led to calls for the president's supporters to impeach these judges. Now, only 15 federal judges have been impeached by the House since 1804, and only 8 had been removed by the Senate. I was involved in one of them for a very severe misconduct case. What's the standard in the Constitution for impeachment for a federal judge?
Well, it's been understood that the impeachment, the constitutional language of treason, bribery, and other high crimes and misdemeanors applies with full force to federal judges, although it's actually not explicit in the Constitution, and there are some scholars who have raised some questions about it. But our practice is consistent that that is the same standard that applies to other officers. It applies to judges. And in terms of how our practice has implemented that standard, it has been exactly as you said. In the 15 judicial impeachments that have resulted in 8 convictions and removals, they have been for serious misconduct, things like habitual drunkenness, sexual assault, or corruption, bribery, those types of offenses. The one impeachment of a Supreme Court justice, Justice Chase, was somewhat different because it involved explicit partisanship from the bench. But there you had repeated jury charges and actually kind of electioneering from the bench that also clearly distinguish the conduct at issue there from any of the rulings at issue here. So just to be succinct, none of these historical examples have anything to do with the substance of the rulings rendered by the judges who were subject to impeachment.
Well, and even for those who cite the section of the Constitution that judges serve during times of good behavior, that wouldn't include disagreement with the outcome of a case.
No, I would say the combination of the good behavior language and the impeachment language has suggested that the way to implement the requirement of good behavior is through impeachment. There is no other mechanism that we have ever used to remove judges other than the impeachment mechanism. And certainly there's nothing to suggest that disagreement with a ruling, whether we're talking about as a matter of good behavior or the specific impeachment language, would ever be the basis for seeking to remove a federal judge.
Senator Chuck Grassley, chairman of the Senate Judiciary Committee and hardly a bleeding heart liberal, recently said, and this is a quote, "You can't impeach a judge because you disagree with their opinion." I take it you agree with Senator Grassley's statement there?
I do.
Now, would doing so be damaging to our constitutional system of separation of powers? And if so, why would that be?
I mean, I do want to be clear that I think that there is a healthy inter-branch debate and dialogue that can include criticisms, including sharp criticisms of the rulings handed down by district judges, appellate judges, Supreme Court justices, and that can include hearings that consider and maybe adopt legislative change, right? Obviously, Congress has considerable authority to regulate the jurisdiction of the federal court, so I don't think any of that is unhealthy or destructive, but I do think that moving into an era in which substantive disagreement with the rulings of federal judges gave rise to impeachment proceedings would involve an escalation of this kind of interbranch warfare and a politicization of the judiciary that would be extremely damaging to judicial independence and to the role of courts in our democracy.
Thank you very much. Ms. Romero, I found your testimony riveting, and I'm sorry that you and your neighbors went through such a nightmare. There is not a single member of this committee on either side of the aisle that doesn't want violent criminals who in this situation to be deported. The issue is standing up for the rule of law, making sure their due process when that is done. And I want you to know that I listened very carefully to your testimony. I'm sorry what you went through.
Thank you very much.
Thank you.